state. The as we go around, if you wouldn't mind sharing your name and your affiliation and what is important for you in this process, we would be grateful. Excuse me. I'm just going to go from the panelist list here on the screen, but I will kind of read off the folks, and it's going to be a mix of RAC members and staff because we'd like to hear from staff supporting the effort too. We'll start with Casaria Taylor and then Amanda Punton, Ed Sullivan, Alexandra, Alexis, we'll go Alyssa and Reese, then Carrie, and city planning. If you could rename yourself, I'd be grateful. Courtney, Crossman, Mr. Honeycutt, Dave, Diane, and just scrolling down a bit here. My computer will let me. Let's see. Great turnout today. Thank you, everybody. So after Diane Tiemann, we've got Alyssa, and then Ellen, Gordon, Jill, John, Katie, welcome, Keenan, Kelly, Laura, Councilmember Anderson, Michelle, Nick, Stacy, and I think that is it. If I'm not missing anybody. So we'll just take it from the top, and if anyone joins after that, then we can catch them at that time. So Casaria, if you don't mind leading us off.
Thanks, Kirsten. Hi, good afternoon, everyone. Casaria Taylor, Senior Rules Coordinator for DLCD.
And Amanda.
Hello, Amanda Punton. I'm the Natural Resource Specialist for DLCD and coordinate implementation of our set of Goal 5 rules.
Awesome, thank you. Mr. Sullivan, Ed.
Yeah, Ed Sullivan, retired lawyer and representing land use advocacy organizations.
Thank you, sir. Mr. Hammer, Alexis.
Good afternoon, Alexis Hammer, Legislative and Policy Manager here at DLCD.
Thank you. And Ms. Bonini, Alyssa.
Hi, everyone. Hopefully you can hear me all right. Alyssa
Yes.
Benini, I'm a Legislative and Policy Analyst with DLCD.
Great. Thank you, Alyssa. Mr. Edwards, Brees.
Sorry, technology is not cooperating. Brees Edwards. I'm the Deputy Tribal Historic Preservation Officer and Manager of the Historic Preservation Office for Confederated Tribes of Grand Ronde. Thank you.
Thank you, sir. Thank you so much for being here. And I know it's a difficult schedule. Really appreciate it. Let's go to Carrie.
Good afternoon. I am Carrie Miller, and I serve the Confederated Tribes of the Umatilla Indian Reservation as their Historic Preservation Officer. So happy to be here today. Thank you.
Carrie, thank you. Mr. Honeycutt, Dave.
Okay, I got it working.
Yay!
Technology is always a struggle for me. Dave Honeycutt, Oregon Property Owners. I have on this rack probably both the development side and the natural resources side.
Thank you, sir. Thank you. And Ms. Tiemann, Diane, please.
Hi. Bijan sabihin na Diane Tiemann Minaniada na Wadada Kanoa. I'm the Culture and Heritage Department Director for the Blanche Heights. Good to see everyone.
Thank you, Diane. I'm glad you're here. Ms. She hates when I do this, but Dr. Boy and Alyssa, please.
It's fine for general introductions. Good afternoon, everyone. Alyssa Bullion. I'm the State Physical Anthropologist with the Legislative Commission on Indian Services.
Awesome. Thank you. Thanks, Alyssa. And Ms. Grover, Ellen, please, welcome.
Good afternoon. Yes, Ellen Grover. I'm legal counsel for the Confederated Tribes of Warm Springs, kind of standing in for the Tribal Historic Preservation Officer, and just here tracking the tribe's interest in tribal data sovereignty and other cultural resource interests. Thanks.
Great. Thank you. Thank you. Thank you. And Mr. Howard Gordon.
Hello, everyone. I'm Gordon Howard. I'm the Community Services Division Manager for the Department of Land Conservation Development.
Awesome. Thank you. And Ms. Rolfe, Jill.
I'm Jill Rolfe. I'm the Coos County Community Development Director.
Thank you. And Mr. Polly, John, please.
Hello, everybody. I'm John Polly. I'm the state archaeologist with the State Historic Preservation Office.
And he wins on books. Yeah. I love that. I love that background. Could we have Stacy Scott introduce herself right now also with State Parks?
Yeah, hope everybody can hear me fine.
Yes.
Okay, perfect. Stacy Scott. I'm the Coastal Region Archaeologist for Oregon Parks and Recreation Department. I've had an interest in Goal 5 for a long time. Happy to see this moving forward.
Yes, thank you very, very much. I'll be getting back to you in a moment there on the history of what we've been doing here. Thank you. Okay, there we go. Katie, Ms. McDonald, please. My handwriting is horrible.
Good afternoon, everybody. My name's Katie McDonald. I'm a tribal liaison for the Metro Regional Government spanning the 3-county area around Greater Portland. I'm here. My colleague Glenn Hamburg, who's one of our principal planners, is also joining the RAC. He wasn't able to join today, but you guys might see him at a future meeting. Thanks.
Great, Katie. Thank you for making the time and welcome, welcome. Keenan, welcome.
Keenan Norton-Bacallion. I'm a land use attorney with the law firm Jordan Ramus and represent private applicants.
Keenan, thanking you. Probably just noticed that I didn't have the nerve to try your last name. I'm sorry about that. Thank you, though.
That is fine. Not many people do.
I'm probably not the first. It's a beautiful one, and they need to get ordered by Callium. Thank you. And Kelly, please.
Good afternoon, everybody. Kelly Hesley Glover. I'm the Community Development Director for Wasco County, and here to represent experiences in the Columbia River Gorge National Scenic Area, where we implement a more aggressive program than Goal 5. Thanks.
Yeah, Kelly, thank you for being our big sibling there. Deep history in that subject. Ms. Laura Kelly, please.
Hi, everyone. I'm Laura Kelly. I'm a DLCD regional representative in the Portland Metro region.
Thank you. And thanks for being here. Kelly's helping work on the implementation methods. Councilmember Anderson, please list.
Well, Clissy, Gawasas, Les Anderson, Tribal Council, the Klamath Tribes. It's a pleasure to be here today, and along with my colleagues and tribal partners. Thank you very much.
Thank you, sir. Really appreciate it. And I'd love to welcome Mr. Lawrence Scumfen III, please, as well. Lawrence, are you able to say hello?
Hello, can you guys hear me?
Yes.
Hello, good afternoon, everybody. My name is Lawrence Scumfen III. I am from the Confederated Tribes of Warm Springs. I have been recently appointed to the Tribal Historic Preservation Officer for the tribes. And looking forward to meeting everybody and working with everybody on this Goal 5. Hello, everybody. Nice to meet everybody.
Thank you, sir. Really wonderful and newly into the Tipo shoes that Confederate Tribes of Warm Springs are really appreciative of you joining this river of project so quickly. Miss Michelle Wright, please load up.
Yeah, I'm Michelle Wright. I'm with the Department of Transportation. I'm a geologist, and I appreciate the inclusion. Thank you.
Thank you, welcome. And Nick, I don't know how I lost you from my list, but Mr. Stern, please.
Good afternoon, Nicholas Starnan. I'm with the City of Portland Bureau of Planning and Sustainability. Glad to be back on the committee, meeting again. And I'm hoping that we can continue to work on the rules and in particular get some additional clarity for local jurisdictions on how to adopt and amend, in particular, the inventories of cultural landscapes for that process.
Thank you, sir. Thanks for being so locked in on that and a good advisor here. Did we miss anybody? I think there was a city planner name.
That was me. I renamed myself.
Oh, there you go. That's why I lost you. Okay, thank you. We found you. Great.
I
Okay.
haven't introduced myself, Kirsten.
Oh, please go ahead. Yeah, Alexandra, forgive me, please.
No worries. I heard myself on your initial list, and I think I switched devices at that point. So that's why you are. Alexandra Ring, League of Oregon Cities, she, her pronouns. I handle our housing and land use portfolio.
Thank you, Alexandra. Thank you. I think I may have on my list. Yeah, I miss you. Thank you so much. Thank you so much. Okay, I will go ahead and share. Did we miss, before we keep going, did I miss anybody else?
One more. Hi, everyone. I'm not sure if I just didn't hear my name. I'm Courtney Crossman. I'm the Tribal Historic Preservation Officer for the Confederated Tribes Coos, Slowrumco, and Icelandians. Thanks.
Thank you, Courtney. Yeah, no, grateful. Thank you. I think I miss you there. Thank you, thank you, thank you for being here. So some folks on this committee have been here a very long time with us. So long in sort of public policy human years, not long in Indigenous history in Oregon. But I just want to thank folks who are just joining, also folks who have been here since kind of 2019, 2020. It's been a long journey, and that's one of the reasons I had to just tag Stacy Scott there. It was a meeting when I was new in my role, and I think it was either a cultural resource cluster or a meeting to discuss the state taking over some federal water quality rules, and someone suggested the relevance of Goal 5, and Stacy mentioned how it hadn't been serving tribes, and I said, okay, gosh, what's that about? And that began the journey. So Stacy, thanks for joining again at this part of the process. It's been a real journey. What we know now, and this is through instruction from Councilmember Anderson, other members on the committee, other coaches, is that Senate Bill 100, a land use planning program we're, relatively proud of. It's a work in progress. It's only 50 years old. It's more comprehensive than any other state in the nation. So it has its positives and its challenges. But one of the real misses with Senate Bill 100 is it didn't mention tribes at all. And that's a regretful part of our history. In 1973, it also came during the time of termination, in the termination era. And that is also a very regrettable time in history. Only the treaty tribes had not been terminated at that time. So the Warm Springs and Umatilla, of course. And then Burns Paiute came into recognition shortly thereafter. So it's as we were, or excuse me, in the 1960s, when cities and counties in Oregon were developing their initial comprehensive plan, that means there was not many tribal nations embodied or quote unquote recognized with whom to consult. So the initial inventories in our city and county plans don't really recognize the many thousand-year history of Indigenous culture in the state. So we know that our inventories are deficient. We know that in 1993, in the mid-90s, when we were amending Goal 5, we took out the definition of cultural areas, and 30 years later, here we are today. So we took that out because the executive order and the state law on government-to-government relations was just new then. And according to what we can see in the record, tribes advised, let's see how this government-to-government relations law and executive order works out. And then 30 years later, we're just now picking it back up. So it is definitely something to restitch together. This won't be perfect. As the commission has said, they welcome this effort and also revisiting this effort. So we'll get as good as we can this time. The tribal representatives petitioned the commission in 2021 to initiate rulemaking on this topic. In 2022, we did a survey of local governments that revealed that local governments in Oregon really do need more information about inadvertent discovery, about government-to-government relations, about tribe sovereign status. So there's a long way to go to help inform community members, local government practitioners, ourselves, about how we can do right by First People and the federally recognized tribes of Oregon. So that continues in 2023. Our commission initiated this rulemaking. In 2022, we did the survey and also worked with a tribal work group of representatives, of many who are on the screen still here with us. So thank you. And then in 2023, the commission adopted the formal rulemaking, which was adopted. In your packet, you have the rules that were adopted by commission last December. There are two issues the commission asked us to spend some more time on. So in March, they gave us a charge we'll cover today. But that's the short history of this rulemaking process. Any questions or corrections to that? Okay, if not, I'll just kind of cruise on into what the commission has asked the RAC to do. So there's as Nick just mentioned, there's, how we process these applications, a very significant topic for local government. So that's our first charge from the commission, is how a local government would process an application to place a culturally significant landscape feature on a local inventory. Gordon will take us through that today. And we'll look forward to that discussion on our second meeting in June. It is who could bring that type of application. We know that the tribal governments in Oregon are very kind of centered in that role. The other culturally identified groups is kind of the question. We'll get to that in our second meeting. The third question is definitely how Metro and the receiving city would coordinate a potentially significant cultural landscape feature in the case of an urban growth boundary amendment. So again, thank Katie and Glenn for joining us from Metro Regional Government for that third topic. In your packet, you all have spent time on so many committees. I know you know the drill, but just wanted to touch on page 5 in your packet to see if anyone had any objection to any of the operating principles. We have the charge there on page 1. We have the organizational structure that, RAC members are serving an advisory role to us as staff. We're incredibly grateful for that. We will draft and present those recommendations to commission for their final consideration and decision-making. RAC members are encouraged to communicate their guidance at RAC meetings verbally or in writing, preferably 1 week following a RAC meeting, just so we can get those in the summary. I'll touch a little in a moment on public comment. But I would say that for the record, if any RAC member wants to provide something in writing for the record, you are welcome to, in addition to these meetings. Staff, Jess, Gordon, Amanda, Casaria, and I, and Alyssa and Alexis are providing committee support and rules coordination. We commit to communicating diverging options on the rule language proposal in our staff report to commission. While we love consensus, that's not a requirement here. We might be together for a very long time if it were, but that would be ideal. We're grateful for Commissioner Thompson as our liaison. And as I mentioned, at the end of the process, commission will be the final decision maker on these rules. And we hope to avoid appeal, but if that happens, then we'll see what the courts have to say. But we're going to do the best we can. In the meetings, we just ask that you make a good faith effort to attend them all. Just for continuity, we'll just have, I think, 4 through this phase of the process. We'll prepare summaries. And again, we ask that you look at those and give us any corrections within a week of receiving the summary. Public comment, this is new. So we are taking public comment at Rules Advisory Committee meetings. We are live streaming the meetings on YouTube, we hope. If not, we'll be posting this to YouTube. We'll be taking public comment and providing those summaries on the department's webpage. If anyone has a free hand, they could put the dlcd.goal5ca address in the chat. That branches out to several of us here. So if you send a comment to that Goal 5 address, it'll reach everyone it needs to. And we'll make time on the meeting agendas for verbal public comment, which we have a period of that coming up today. And I don't see, let's see, oh, Miranda is here, wonderful, perfect timing. So we do have an invited testimony that we can get to in just a moment here. The close of public comment, we anticipate that the close of consultation and public comment will be October 5th at nearly midnight. Secretary of State only lets us publish in 5-minute increments, so that's why it's not 11:59. The public hearing, we expect to be at the commission's September meeting. And I'll just pause there to see if there's any questions on that, on kind of that sort of setup so far.
Kirsten, can I jump in with something, and
Go ahead.
unless you're going to get to it later,
Yeah.
the distinction between comments to the RAC and comments to the commission?
Yes, just yep, let's just take that up right now. Thanks, Amanda. So right now, during everything prior to September 1st is considered comments to the RAC. So folks, Miranda's here and we appreciate her testimony today. That's informative for the RAC's process. And then after September 1, we'll capture any public comment after the Secretary of State's notice, and that will go into the commission's deliberation. We as staff will be creating a response to all the public comment by theme, and that will include both periods, but there is, Amanda's right that public comment now is for your all consideration, and then public comment after September 1st, after that September 1st Secretary of State notice, that will be for the commission's consideration. We will meet once after the public hearing, just so that we can all huddle and talk about what we heard and see if there's any final changes. So there's a little overlap there between the two periods, but that's the distinction. Thanks, Amanda. In terms of member expectations on that page 6, and on the screen, we appreciate you bringing up concerns for discussion at the earliest point possible so that we can address them. Please share any relevant information. Don't be shy about bringing that forth. That's why you're all here, and we love to hear from you. If you could keep your government or your organization's leadership informed of recommendations being formed by the RAC, we'd be grateful. And then definitely review and comment on the draft and revised draft rules, impact statements. We'll look at the impact statements in our 3rd meeting, and other strategies and documents. We ask that everyone listen with respect. We've never had a problem with that in this forum. Hear each other out without interrupting, and allow for a balance of speaking time. Be tough on issues and questions rather than people and organizations, and discuss things together rather than in the virtual hall, I guess I would say. Seek to resolve differences and reach agreement where we can. We understand that you'll have to take calls, but feel free to go on mute or off camera if you have to be away. And if you can be on camera, it's just, we love the humanity of being able to see each other. We know that's not always possible with folks driving and working and multitasking. So we're a big believer in food first as well. So if you wish to eat or snack, please do so. We would ask that you don't email the full RAC. Email us, please, at that email address. If we are emailing each other, that's a breach of public notice as a group. So please refrain from doing that. We'll share anything that you'd like shared with the RAC for you. I've gone over the schedule, but we expect that we'll meet for 2-hour meetings in May, June, July, and September. And then the proposed rules being up to LCDC at their hearing in September, and adoption in October this year. So again, pretty ambitious schedule, but that's how we do apparently. And if we can get the implementation pretty soon here after a 4 or 5 year run on this. So thank you, everybody. Any questions on or objections to the operating principles or guidelines, or questions about the charge for the commission? All right. We'll take a break in August. So staff will be scrambling, getting everything ready for the Secretary of State notice, having Department of Justice review. And then that draft rule period open for public comment on September 1st through October 5th, as Amanda was mentioning. All that material more should be in your packet. Thank you. Okay, I think we're ready for the meat of it then, which is wonderful, which is why you're here. Hey, Miranda, yes, thank you. Just save me. We'll pause here. I'll take the slideshow down. And we're really pleased that Miranda Miller is here. And Miranda, are you comfortable coming over? Is she over as a panelist so she can come? Okay, Miranda, we're just gonna promote you in case you'd like to come on camera with us. Thank you for being here.
Thank you so much, everyone. Hi, my name is Miranda Miller. I'm gonna stay off camera just because I'm in the Capitol building and
Okay.
there's no real good place for me to put my computer. So
yeah.
All right, I'll go ahead and get started. Good afternoon, everyone. Thanks for the time to testify today. My name is Miranda Miller, and I represent the Nez Perce tribe, who is a federally recognized tribe. Since time immemorial, the Nez Perce tribe has occupied and used over 13 million acres of land, now comprising north central Idaho, southeast Washington, northeast Oregon, and western Montana. Northeast Oregon and all of what is now Wallowa County, whose name is a Nimiipuu word, is the homeland of the tribe. The treaty with the Nez Perces, signed on June 11th, 1855, created a reservation that stretched from northeast Oregon through southeast Washington and north central Idaho. In 1863, the United States attempted to force the Nez Perce to sign a new treaty. In this treaty, Nez Perce land was reduced by almost 90%, removing 750,000 acres of land in Washington and Oregon from Nez Perce control. Many chiefs refused to sign and relocate, eventually leading to the Nez Perce War. This is how the Nez Perce came to occupy their much smaller current reservation, which does not include parts of Oregon or Washington. Despite this, the tribe continues to exercise treaty reserved rights, particularly in fishing, hunting, and land and resource stewardship in Oregon. To this day, the tribe's offices in Oregon complete work as fisheries co-managers in coordination with ODF&W to provide for local fisheries that benefit both Indians and non-Indians. The tribe's Department of Fisheries Resource Management Office in Joseph, Oregon, which is part of the original homeland of the Nez Perce, has 19 employees that staff research, production, and watershed divisions throughout Northeast Oregon. The strong bond between the tribe and Oregon is perfectly symbolized in the engraving of Chief Joseph's name in the House and Senate chambers of the Oregon State Capitol building. Unfortunately, because the Nez Perce current reservation does not stretch into the state of Oregon due to that 1863 treaty, the Nez Perce are left out of many engagement processes with state agencies, local governments, and more, which results in a critical loss of culture and history. One such example of this loss of culture can be found in the tribal curriculums developed after the passage of Senate Bill 13, which sought to create a Native American K-12 curriculum for Oregon public schools. The Nez Perce were completely left out of this process, meaning that not only was no curriculum about the Nez Perce developed, but a statewide map that attempted to show the tribal footprint was developed, and the Nez Perce are inaccurately, their history with the state of Oregon is inaccurately represented on the map. This map and other curriculum materials will be utilized by schools across the state, harmfully erasing the historic ties the Nez Perce has to Oregon. As you all strive to determine who can bring an application forth to amend a comprehensive plan to place a culturally significant landscape feature on a local inventory, and how local governments should process this type of application, the Nez Perce tribe urges you to consider the deep culture and history that may be lost if the Nez Perce are unable to bring forth an application such as this and/or engage with local governments on the process of the application. We strongly urge this committee to ensure that tribes that have treaty reserved rights in Oregon be able to bring an application forth to amend a comprehensive plan. Thank you.
Miranda, thank you. Super helpful. And I think you hit just about, you hit 3 minutes. I think you're 2 seconds off. That was amazing. We weren't going to stop you anyway, but that was impressive on a number of levels. Thank you for bringing that, thousands and thousands of years of history and culture into the room. We're really grateful.
Yeah.
And if you're able to submit those comments in writing, we'll put them in the record now.
Okay, great.
Thank you.
Thank you. Really appreciate the time and the work you all are doing. And I will be back at future RAC meetings. So if you all have any questions that I might be able to answer in the future, I'm happy to, make sure those questions get answered.
Wonderful. Thank you for riding along with us. We're grateful indeed. Good. Okay. Wonderful. I'm going to put the slideshow back up and just move into one where I would invite Amanda to recenter us on the architecture of the rule, and then Gordon's going to take us deeply into quasi-judicial versus legislative amendments, things that no planner is taught in graduate school. So I'm getting some good overview here. No, yeah, not I at least. But things hopefully have changed at the U of O. Go Ducks. Please, Amanda.
Yes. So I know that most of the people that are in the meeting right now have had a lot of experience with this rule, but not everybody. And then there's some people that might be listening in on the Zoom channel. So the rule, includes these sections, definitions, pretty obvious reasons for that. Relation to other rules, because Division 23, which is the division within OAR Chapter 660 that these rules live, sometimes interact with each other, or they speak of things that like resources that might be overlapping. Then Section 2 of the rule talks about how to deal with other rules involving Goal 5 resource categories that overlap with cultural areas resource category. And then in Goal 5, a lot of the way we think about implementing Goal 5 is identifying where there are places that need to be looked at, identifying which of those places are more important and thus significant, and then moving on to a process or directives for how those significant resources are protected. And sometimes the directives can be in rule. Other times the rule explains how a local government will come up with measures to protect. So the order in this rule is that we first talk about inventories. So we talk about inventory of archaeological sites, and then talk about inventory of landscape features. And then we move on to talking about protection. So first, protection of archaeological sites, which relies basically on providing notice to tribes and making sure there's opportunity to flag where there could be a conflict with a known or suspected archaeological site, and then kind of letting the existing state laws and statutes that apply to archaeological sites act as they would need to act if there was indeed a site there, and if potentially a site was disturbed. Then protection for landscape features, that protections will be the responsibility of a local government to devise, and there's some direction for how that happens, but a lot of that process is described in another section of Division 23, or another rule in Division 23. And then landscape areas of interest, that's because we know that there will be important landscape features that well, certainly don't now and may not get to the point soon, or we don't know when, ever, of actually getting local protections, but there's opportunity to still talk to property owners and developers to try to avoid impacts to those important landscape features. And then there's also description in there about how those landscape features might be kind of brought into a process that could lead to adding a site to a local inventory of significant sites. And then Section 8, optional local protection measures. I won't go into any detail there, but I encourage you to look at them. I guess I will say that it describes one pathway of tribes and a local government, or a local government developing a memorandum of agreement with one or more tribes, and that could take the place of some of the prescribed notification procedures in this rule. Make something that works best for the tribes and for the local governments, and have them agree to that. And then there's another part about anticipating possible impact in areas of known high archaeological site concentration. And then the application of the rule. I can't even remember exactly what's in there, but I'm sure it's really important. So today we are going to really just be talking about the section 4, because we're going to be talking about one mechanism through which a landscape feature could be added to a local inventory of significant Goal 5 resource sites.
Thank you, Amanda. That is great. And for folks that have your printed copy of your packet by your side or on your screen, the section 4 that Amanda just described is on page 14 of your packet. And Gordon, are you prepared to share screen with your memo, or how would you like to do?
Well, do we, let's see. I think that, how would you like to do this, Kirsten? I mean, we have the table up there now, and then I have my notes that I can speak to that we sent out. So
Sure, go ahead. If you just want to speak from this screen, I think that's fine.
yeah, that would be fine with me.
Yeah, and folks, you know, Gordon is speaking to the memo. The memo itself starts on page 9. So fasten your seatbelts. Here he goes.
Okay.
Thank you, Gordon.
Thank you. Well, as was mentioned, what we're talking about here is the rules as written now state that a landscape feature to be added to a city or county's Goal 5 inventory, which is the first step to determining whether it's significant, and then if there are conflicting uses and whether it should be protected and how. The question is, what kind of an application is that? And the two options are what's called and I'll get into what this means, a quasi-judicial application and a legislative application. But to give you some background on what the difference is and how this all works in the statewide planning system is what my hope is to help you with today. And Kirsten, I suspect if graduate students at the University of Oregon were made to learn this, half of them might have left the program. So maybe we should reconsider whether that should be part of the curriculum there. Anyway, so first of all, there are actually 3 different types of permits or applications, permits that local governments can apply in a land use context. And the first one, we're not going to talk about too much today, is an administrative permit. And that is really, it's not a land use decision even. It's a permit that doesn't involve any discretion. A classic example of that is a building permit. You meet the standards set forth in the building code. A technically proficient building official reviews that, and the city issues a permit. There are other similar types of permits, a lot involving engineering standard, engineering road standards and things like that fall in this category. What we're really going to be talking about today more is the difference between a quasi-judicial permit and a legislative permit, and responsive, actually, application that results in a decision by a local government that's either quasi-judicial or legislative. And the distinction is important, as you can see later in the list here. The distinction is important because it's very different. Local governments very different procedural standards and requirements set forth in state law for each of these type of permits. For a legislative permit, that is something that applies. The classic example of a legislative decision, I should say, by a local government is a adoption of a comprehensive plan or amendment to a comprehensive plan that affects large numbers of people, large areas, that doesn't require the local government to make a decision. In other words, the local government considers an amendment to a comprehensive plan and says, well, we don't want to do it. They can just drop it right there. There's no requirement to make a decision. And these are called legislative because the decision makers of the local government are acting in a legislative capacity. It's the equivalent of being a member of the state legislature deciding on whether a law should be passed or not. The state legislature, doesn't pass almost all the laws that are put before it, and that's their prerogative. They're not required. They don't even have to make a yes or no decision. They just say yes or they say nothing, and the bill and the proposal dies. And that's the same thing with the local government in a legislative decision. Legislative applications don't have to be noticed to property owners generally. There's one significant exception to that, set forth in state law. If the proposed changes would change the zoning or reduce the property value of the property, there is notice to the property owner required. There are no requirements listed in terms of who the decision makers, the legislators, the local county officials, whether they be planning commissioners or city councilors or county commissioners. They aren't limited in the information they can receive. They can talk to anyone they want. They can look at all sorts of information. They're not confined to a certain record. There aren't any requirements for public hearing procedures in state law. Some local governments set their own procedures, but in their city codes or charters, but that's their prerogative and decision. That's not mandated by state law. And there's no timeline for a decision either. The local government could make a decision in 2 months or 2 years or never. So the one thing that is required is that the state's ethics laws do apply, and also some kind of legal rules regarding bias in the decision makers apply as well. So that's really a legislative decision. And then we get into the other category, which is called a quasi-judicial decision. And that name indicates that the decision makers, the city commission, the county commission, the planning commission for one of those jurisdictions, or even a local hearings officer or even a planning administrator, is acting not quite as a judge, but almost as a judge. And as you may, I'm sure know, that a judge in a legal proceeding has very strict rules of legal conduct and requirements that the judge must meet in conducting a proceeding on a case or controversy. And similarly, although the decision makers in these areas aren't judges, they're not lawyers, they are required to act in a way, a way that is close enough for government work, for the work that the legislature has set forth. A quasi-judicial decision generally applies to a limited number of property owners or a single property owner. For example, a single property that someone proposes a division of land into 2 or more lots, proposing a zoning variance. They want to reduce the required setback to the yard, the front yard or the rear yard. You can think of all sorts of examples of these kind of decisions. And the nature of the decision is not to set policy, but to apply that plan or code that has been set by policy to a specific application and interpret the provisions in the plan or the code as necessary to make a decision on the specific nature of the application. In other words, someone submits an application for a land division into 10 lots. The local code may say each lot must be at least 5,000 square feet and must have access to a public road, and the decision and many other things. And the decision that the decision makers will then look at those standards and apply those standards to the application to make a decision. Public notice is required to neighboring property owners for that. Many cities and counties require additional notice, but there is a minimum requirement to neighboring property owners. A public hearing is either required or is required if a person who receives notice requests that public hearing. There are very prescribed public hearing procedures that have to be followed by the local government, involving opening the hearing, continuing a hearing, to, if someone requests it, how information comes in, allowing everyone an equal amount of time, the applicant and any other speakers, those sorts of things. The decision makers are limited to considering only the record before them, whether it be the written material, the application, the staff report. And also oral testimony they receive or written testimony they receive on the application. They are not allowed, generally not allowed to go out and do fact finding on their own, as with the legislative situation. They're not allowed to, if someone at the local supermarket says, I have an opinion about, the subdivision of this 20 acres of land near my property. They're supposed to say, I can't talk to you about that. You have to come to the public hearing and raise your concerns. If they do accept that amount of information, it's called an ex parte contact, which means outside of the proceedings in Latin. And they have to disclose that at the hearing and allow anyone to question the content of what they heard and discussed. They have also, by state law, very timelines to make a decision, and they have to make a decision. They have to approve, deny, or approve with modifications an application before them. And if they don't meet the state deadlines, which are generally 120 days from the date they get a complete application for cities to 150 days for counties, the applicant could go to court and compel a decision, and the judge in that case will make a decision and generally will approve a project unless it's completely in variance with the city's comprehensive plan. So there are pretty strict standards. Also, the ethics and bias laws that apply to legislative provisions also apply to quasi-judicial. So as I describe these two types of applications, you can see that the legislative decision-making process is much more open, free-flowing, if you will, and can come to a decision or not to a decision, whereas a quasi-judicial application has to result in a decision and has a lot more pitfalls and areas where a local government can, if you will, mess up and get on appeal, which an applicant for either of these type of applications or an interested party who's participated at the local level can appeal these decisions to the Oregon Land Use Board of Appeals. There's a lot of ways, more ways in a quasi-judicial decision that an applicant can get tripped up, or a city can, or a county can get tripped up, I should say. Now, in many cases, it's very clear what a quasi-judicial type of decision is versus a legislative decision, but it's not a fine line. And there are many cases that have gone to court over the last 40 years of an application that someone asserts that a local government has misapplied, whether it's a legislative decision or a quasi-judicial decision. And I believe every one of those cases is that the city or county processed the application as a legislative decision, and the claim is that it should have been a quasi-judicial decision. Because you can see, no one ever complains about having too much process. They complain about having too little process. And since the legislative decision-making process has a lot less fewer requirements than quasi-judicial, that's the way the complaints go, or the assertions of error that have been challenged. And so, since there isn't a fine line, there is a famous court decision from, I believe, the late 1970s. It's the Strawberry Three Wheelers versus Benton County, a very colorfully named decision. I have no idea what the actual controversy was about, but the Supreme Court of Oregon at that time made some findings about what constituted a legislative decision versus a quasi-judicial decision. And unfortunately for everyone, it's a very subjective, it's a fairly, well, not very, but fairly subjective difference. Those three things are, first of all, there are three questions that have to be asked by the decision makers about whether it's legislative or quasi-judicial. Is the process bound to result in a decision? Is the first one. The second is the decision bound to apply pre-existing criteria to concrete facts? And the third is the action directed at a closely circumscribed factual situation for a relatively small number of persons? And the answers to these questions are often in dispute, and a lot of these cases that you read about in the various records of the Land Use Board of Appeals or the Court of Appeals start weighing and balancing these three factors, and well, maybe this is true, maybe that's true, and there's not a good fine line here. The courts have said that the second factor of these three is less important than the other two because you often in even legislative cases have to apply pre-existing criteria to concrete facts. So, but the first and the first and third questions are answered with the answer no, then the decision is almost certainly legislative, not quasi-judicial. So anyway, as it relates to these rules, if someone applies and we have to decide, we're going to be talking later in the process of a subsequent meeting about who can apply for to the local government to declare an area as a significant landscape feature of cultural interest. For the local government to review it, they have to decide whether, they have to look at these three criteria. For instance, does it apply to, if, for example, if the Nez Perce tribe were to apply for a provision involving thousands of acres of Wallowa County that involved many, many property owners and, a large range of area, and it might be that is, and it was for a fairly, generalized type of significance, based on factor number 3 here, you would say, well, that's a legislative decision. If a tribe somewhere else let's not even take about a tribe, let's say a local cultural organization of some sort said that a specific site on a 1-acre property along a local river has significance as a fishing site of some sort. And it was just one property, and it involved a specific issue of catching a certain type of fish. Factor number 3 would indicate that that's the answer to that is yes, not no, and that should be more likely be a quasi-judicial decision. The problem, we looked at the issue of whether in our rules we could declare something was a legislative decision or a quasi-judicial decision and say, doesn't matter what kind of application it is. If it's an application for a landscape feature of cultural interest, it's a legislative decision. And our Department of Justice attorney let us know that this is not, this is a legal requirement, this is a legal test set by the Oregon Supreme Court, and he questioned whether, we could just declare in our rules that something was legislative if these 3 factors clearly indicated it was a quasi-judicial decision. In other words, you can't say a dog is a cat in your rules. And so that's kind of where we are at this point in the process. And hopefully this has been of some help to you in some background on trying to resolve this issue. And unless anyone has any questions.
Gordon, thank you. I think there is a question. Can you see the panelist hand up? Oh, it's Nick. Thank you. Please, Nick.
Yeah, thank you. That was very helpful. I can see where it's a legal test and you have to make a determination, particularly number 3. But it seems like that's a different kind of criterion than 1, because 1 is something that's specified in some sort of code or procedural rule, right? It's like you have to say, the local jurisdiction has to say whether a decision is required or not. So I'm just kind of grappling how you apply number 1 in the test.
That's a very good question, Nick. And I think the best answer I would give you is if you'd have to look at an individual situation. For instance, if a city received an application to, I don't know, if a city decided it needed to look at expanding its urban growth boundary, Metro, for instance, a good example was what Metro did about 10 years ago now. Metro looked at whether there was a need to expand its urban growth boundary. There's a 20-year land need, and this was back in about 2014. Metro determined that they thought they didn't need to. And there were quite a few members of the development community who didn't agree with that, said, no, you actually don't have enough land for your expansion. But to their frustration, Metro, didn't have to make an action saying we hereby do not expand our urban growth boundary. They just took no action, and so there was nothing to appeal. And I think that also happened to some extent with the city of Eugene several years later, a similar situation. That's, my expertise with the agency has been with urban growth boundaries, so I'm familiar with those kind of situations. This test, I don't know, perhaps Mr. Sullivan, who has had even much more experience with this than me, has some thoughts on that. But these provisions are pretty subjective, let's just say, and that's one of the problems with trying to, it's been a problem with this throughout Oregon's, land use history since the question started coming up.
Ed, do you want to chime in there?
Yeah, generally, I agree with what Gordon said. It is almost a case-by-case determination. I think the rules should reflect the alternative of a proceeding being legislative or quasi-judicial, and advising local governments of the rules for each. And I think that's one of the objectives of this exercise today. And I think it's a good one. And you're not going to be able to reach a definitive conclusion about what the proceeding is for every case in futuro. And I think what the department has done is to try to
if I could phrase my question a little bit differently.
Nick, just real quick.
Yeah.
Let's let Ed just finish his thought
No,
there.
that's fine.
I'm sorry. Yeah.
Go ahead, Nicholas.
If just for sake of argument, a application comes in through a quasi-judicial, it clearly meets the quasi-judicial test under 3.
Right.
If the local jurisdiction, does that mean the local jurisdiction is also bound to make a decision? You see what I'm saying?
Yeah. And that's why they call them factors in the Strawberry Four-Wheelers Association. You have to balance these things. If it relates to a small number of properties and somebody's making the application, I think the local government has to make the decision.
Okay. Helpful. Thank you.
Thank you both. We have Katie and then Dave. So please, Katie.
Thank you. I have a question that actually goes back to the former table and just the implementation of a quasi-judicial decision. So if Dave or Brees have questions that are continuing the thread we're having right now, I can hold my question till they're done.
Okay, Dave, I know you popped up right during that time. Did you want to address kind of the test?
Not so much address the test, but just ask how a local government can be bound to make a decision on a quasi-judicial Goal 5 request when the local government's determination of what level of both significance and what level of protection, if any, they want to afford to the site, at least under the current rules, rests entirely within their discretion.
Dave, can you say that like 3 times again so I can get it?
Well, let's say there's a determination that the application is for is a quasi-judicial application.
Mm-hmm.
The local governments, under our, at least as I understand our current Goal 5 rules, the local governments, both the significance determination of the resource site and the potential protection that the local government decides to place upon that site, anywhere from we're going to completely allow conflicting uses to we're going to fully protect the site and allow no conflicting uses, is a completely discretionary determination made by the local government based on what the local government determines. In other words, it's a policy call as opposed to a did you meet the criteria or not? So I'm not sure how we can have a quasi-judicial, how the local government can act in a quasi-judicial capacity when making a determination under Goal 5.
I think that's an interesting point, Dave. I think what you're basically saying is that for these kind of decisions, your assertion is that factor number one would never be met because a local government is not bound to make a decision on a Goal 5 significance determination, regardless of even if it was only one property and clearly met number 3. I think that the issue there is that I don't know if that issue has been thoroughly litigated or decided in a court case, and a LUBO or a court of appeals would start saying, well, which is more important, factor number 1 or factor number 3? And I don't think we know the answer to that. I think that's the problem.
Well, I don't want to be the one to raise it, Gordon.
Okay.
We appreciate that. We appreciate that. That's great. And so I think folks, we have some new members joining. We did remove the adjective last year. So we had proposed legislative, and as we were looking at kind of this application, we thought, well, we better leave it more open in the case by case situation. But that's one of the reasons we're discussing it again today is are we still on the right track? Reese, do you have something on this topic, or do you want to follow Katie, sir? It's okay, you're close. There you go.
Sorry, there.
Yep.
Let me lower my hand. Yeah, no, on this topic, and I'll confess I wasn't able to hear Katie when she was speaking, but on this case, can you reread what the third test was?
Sure. Go ahead, Gordon.
Yeah, the third point is the action directed at a closely circumscribed factual situation or a relatively small number of persons?
Okay, I guess so. My question is around the word relative. Is that a percentage? Is that who's defining that? And is it at a given moment, or is it over deep time? And I'm saying that I'm coming from a tribal lens worldview that would say something that impacts a place that is expected to be present in perpetuity over time, that's an aggregate large number, not a small number.
That's an interesting point. I think you could also argue similarly that even if you had a if you had a 10-lot subdivision, it would have a very small impact today, but if over time immemorial, there might be many people who lived in that subdivision or were affected by the traffic from that subdivision or had interactions with the people of that subdivision. And I think that doesn't sound to me like the best way to look at it. I think we're looking, when you say relatively small number of persons, we're looking at a present time, not time immemorial into the past or the future.
Okay, and that's helpful. I'm just going to come out and say, if the intent is for there to be inclusion of tribal considerations in this as a part of the process, are we about to cut that out by process? By saying it's this or that? Are we losing intent out of what the Goal 5, all of this work has been about?
Interesting. Thank you, Reese.
Yeah.
We're all scribbling away over here. Thank you. And I say, let's just let that hang. It's a very provocative question. And I also just want to mention, Amanda, you might have a clarification on this point, but I want to welcome Brandy Newsom from the Cow Creek, Band of Umpqua, Tribe of Indians, and also Peter Hatch, the Select Indian Tribes, and Governor Kotek, Tribal Affairs Director Radford, who are here listening as well. So thank you all for making time to come in today. Amanda, did you have one clarification on this point? No, we'll get over to you.
I did want to piggyback on Breeze's point, and I'm thinking not necessarily over time, but when I've seen that idea of that the decision was limited, I don't know, why have I heard it in my mind as a small number of properties? I didn't think of it as a small number of persons. So, so if it's persons, and let's say it is one or two properties that are owned by, 2 to 4 people, but yet the interest for protecting the resource is all the members of a tribe, then which group of persons are we looking at? The persons who own the property or all the members of a tribe?
Again, good for the framing. And then maybe we could, Gordon asked to clarify with Steve if it is persons or property owners, but the persons is definitely open to more expansive interpretation. So we should check on that. Good. All right. Well, Katie, thank you for your patience, ma'am. Did you want to go back up into the table a little bit?
Yeah, thank you. And I want to caveat this question with, like, I am not a planner. I'm not an archaeologist. I don't have an ounce of the expertise that's in this room. So I'm going to apologize if this is a goofy question. And Kirsten, if it's better to address this later in implementation guidance, happy to hold and wait for this. So my question is about a quasi judicial decision that has to be made, and it's a 120-day time frame for cities and 150-day time frame for counties. First question to Gordon is, are those two timeframes inclusive of the appeals processes to be resolved in those timeframes? And then the next question is, if that is the case, a hypothetical example of a quasi-judicial decision that has to be made in the greater Portland area, we have 20 plus local governments cities who may have a decision that they need to make. We hear from LCIS regularly that there's anywhere from 2 to 4 tribes that need to be notified and consulted simultaneously on the actions that Metro does. So how do we develop implementation guidance for this process for a city with a 120-day time frame that actually allows for meaningful tribal consultation and response, especially if that time frame has to be inclusive of the timelines for an appeals process? I'm worried that would lead to very small timeframes or response windows for tribes to potentially have to comment on multiple concurrent applications.
Yeah, thank you for your question, Katie. And yes, the 120 or 150-day period does include any potential appeals, and any competent local government planner probably has nightmares about meeting or not meeting the 120 or 150-day application, with all the things that can go sideways, or issues that can arise and how to resolve them within the timeline. Now, an applicant can and often does extend that timeline especially if they think their application might be denied, if they stuck with it to the 120 days, and we're stickler to that. But in terms of your question about how tribes interact in this process, given those limited timelines, that was a topic quite a bit in the earlier racks that we had a discussion about this, and I'd have to defer to Amanda about how it does put in a significant burden, if you will, on tribes receiving the notices to go through them. I'll turn it over to Amanda. I see she has her hand up. She may want to comment on that.
Yeah, thanks, Gordon and Katie. I want to make a distinction between the applications that we're talking about today, and discussing whether these kind of applications, which I'll say in a moment, will be processed quasi-judicially or legislatively. we're only now talking about someone coming to a city or county and saying, we want to submit an application and pay the fees for whatever that costs to have the city or county go through the steps to add a site that they have described to the local inventory of significant resources. And then the city or county, if they do identify it as significant, they would then have to do the next step of figuring out what were the appropriate protection measures. So let's say that application was brought by a tribe. I could see that there'd be other tribes that might also be interested in weighing in on that, the review and that decision-making process. And I'm going to leave that there. And then I'm going to talk about the other types of applications that this rule talks about in other sections of the rule, which are about applications that might come into a local government for all kinds of things that would just result, that are already allowed in the code and could result in ground disturbance. And it's that whole much larger universe of applications that would require notice to tribes, and that has to happen within the time frame of the local government making their decisions. But those decisions aren't comprehensive plan amendments. Well, I'm going to hold off on that. Maybe some of them are, but some of them aren't, and they are decided on a shorter scale, on a shorter time frame, and whatever input a tribe has would have to fit within that existing time frame. So did I explain that well enough? That this particular kind of application that we are considering with regard to this table that Gordon has provided, and the whole discussion of a quasi-judicial versus legislative review.
Amanda, I think so, but did you do the 7 days prior to a complete application? Part two?
This wouldn't apply to that, I don't think. I mean, we haven't really talked about that. The 7 days prior would be, so if someone's coming in and saying that they want to do a subdivision, and the subdivision we know would result in putting in some roads and utilities. So that's a kind of application that a city could receive that would then require a notice to tribes. And if you want to talk about that part of the rule does say that, gives timelines for when the notice is given to tribes for those.
Okay, so Katie, I think that was our effort here to try and get things earlier over to tribes in instances where there's a ground disturbing activity that calls for public comment in writing or verbal. So that was our effort. We know that 120 days, 150 days are very tight timelines. They're set by statute, and so we're sitting in that world. They don't have, obviously, I know everyone on this call knows that we can't do what the legislature can do in this room. So they would need to take care of that. But our effort to create additional time frame and notice was to go upstream a little bit and have ask local governments who notice tribes who declared an interest in being noticed within 7 days of receiving an application during the completeness window. So the tribe would at least have a little bit advance heads up before the 120-day clock begins. I don't think that takes care of meaningful tribal consultation response, but it was better than no change from the 120 and 150-day timelines. Love to hear from Dave, and then Katie, if you want to kind of wrap up and see if you had anything else there. Otherwise, I would love to hear from Kelly and Jill, Nick at local governments on kind of how they're feeling about these application, how in Coos County things run today, how, Jill, you would see an application like this coming in, if we seem like we're on the right track with, a case-by-case approach, or if there's a world in which we can make it legislative, we want to talk about that very seriously, and over the next couple of meetings, then also make sure we're aware of the cons of the legislative process, which also means that there's no requirement that decision ever be made. So something could hang in stasis for a long time. Dave, please.
Well, just a point of clarification that might make things a little bit easier. If you're talking about the subsequent application, once a significance determination has already been made and somebody wants to come in and apply for a use that may conflict with the Goal 5 resource, then in most likely that's going to be subject to either the 120 or the 150-day rule. But if you're talking about the determination of whether or not to add a site to the Goal 5 inventory, that's I would think always going to require an amendment to either the comp plan map or the zoning map, and amendments to the comp plan map. If you have to amend the comp plan or a land use regulation, the 120 and 150-day rules don't apply. So in that circumstance, you would have a longer period of time.
Mhm.
The local government would have a longer period of time.
So, Dave, you're saying it's always going to be, regardless of whether it's just one property owner, you're saying it has to be processed legislatively because the change is actually to the comprehensive plan, and those changes can only be done legislatively. Is that?
No, I'm not saying that. I'm not raising the point that I raised earlier. What I'm saying is that the 120 and 150-day rules that the legislature has imposed for 30 plus years do not apply in situations where you have an amendment to the comprehensive plan or the local land use regulations. And since cities, and correct me if I'm wrong, Nicholas, or maybe Alexandra, but I think almost every city that has a Goal 5 inventory keeps a Goal 5 inventory map as part of either their comprehensive plan or their zoning code or both. And as a result, if I want to add a Goal 5 resource onto the map where it currently doesn't exist, I'm going to have to amend that map, which means my application is not going to be subject to the 120 or 150-day rule, statutory rule.
Thank you.
And I thank you as well, Dave. Even though I was never taught any of this in school, I've always felt that there was something there around that map amendment. And Ed, you put something in the chat. Amanda, go ahead, and then Ed has put something pretty instructive in the chat.
Yeah, I think that there's a difference, of course, between archaeological sites where it's almost always added as the result of the historical officer or a tribe. For the landscapes, I think that's discretionary. And I don't think there's an obligation by the county to proceed. I think they can just say no, and it's not bound. There's no decision that is bound to be made if the county decides not to proceed on that otherwise quasi-judicial decision. So I think there is a real difference here, and I think we need to look at it. I gave you the citation from the statute, 197-620 sub 1. And I think this applies to all Goal 5 resources that are brought in as a legislative or quasi-judicial matter. The county is not bound to proceed.
Or city.
Or city, yeah, and that would occur for UGB changes, yeah.
Thank you. Interesting. Okay, this is really interesting discussion. Amanda, please.
I just wanted to say that I appreciate, Dave, what you're saying, and I'm maybe learning something myself here. I know that for aggregate sites, that the process for if somebody applies to have a significant aggregate site listed on a county inventory, that whole review has to happen within 180 days. But I guess that is imposed by our Goal 5 aggregate rule as opposed to statute. Okay.
Right.
Thanks all. Katie, anything else you want to round out on there before I turn and see if I can entice Jill to make a comment here?
No, thank you for the discussion.
Thanks, Katie. It's a really great question. Jill, how are you feeling about the discussion so far?
I guess I'm a little bit confused still. I mean, so when somebody comes in and they're in rural residential or urban residential or whatever, and the dwelling's permitted and the only consideration we have on this property is the inventory for cultural resource protection. We send a notice to the tribe and they 30-day respond, but we're not actually making a decision that, you know, we're relying on the tribe to kind of tell us whether they want to be present when somebody's there to excavate or whether there's a SHPO permit involved or like that. So I guess I'm trying to picture how this changes that type of process when it's not a conditional use, it's not an amendment rezone, and these are just over-the-counter permits. And two, or maybe it wouldn't come into play until you reached a certain threshold. I'm just trying to picture this. I'm just trying to figure out if now we're saying this turns all decisions to conditional use it, or you know, what that looks like.
Right, just real quick on that one, it would be these are an application for, right, so it's right in the chat that, right, now we're talking about that 4C in the rules, which is, an application to, amend, let me just pull up the language, sorry, I forget which computer I'm on here. Let me pull up the actual. It's on page 14. Thank you, ma'am. Like, what did I just say 5 minutes ago? So here it is, a local government shall process an application for amendment to a comprehensive plan to place a culturally significant landscape feature on a local inventory. So this is, Jill, this is just a case, not to diminish it, but this is a subset of applications. This would be an application for amendment to a comprehensive plan to place that culturally significant landscape feature on a local inventory. And Dave's distinguishing that from actually the step where you determine significance. So that's an interesting distinction that we've kind of unpacked today, which is the distinction from inventory versus protection might be another nuance that we look at too.
Okay, so all of our goal 5 resources are inventoried as part of our comprehensive plan. And so we're not, when we amend anything in our comprehensive plan, because that means it's it's not one property, right? It's a broader thing. Any inventory you have to add, we have to actually modify the entire inventory to, even if it is that one site. So it is not subject to the timelines.
Right. Thank you, Jill. Yeah. Thank you. Which was the original track we were on back, you know, when we did the original Secretary of State notice. Folks will remember that it did say legislative, but then we were like, oh, did we get that wrong? So thank you, everybody, for the extra after class time here today on this one. Kelly, please, yeah.
I just referenced our land use and development ordinance, and we don't currently have, with the exception, I think Amanda makes a good point about goal 5 mineral aggregate resources. That is a sort of unique feature of our inventories, where people can bring sort of quasi-judicial like applications to amend the inventory. But other than that, we currently don't have a process to allow citizens to submit an application to go through a legislative process. And my concern would be that probably most other counties are in that boat where and it's not doable, but you know, I think we would need pretty specific guidance on how to carve that out in a way that it is like goal 5 mineral aggregate resources. So it's just unique to areas of cultural significance and doesn't suddenly open the floodgates for citizens to propose legislative amendments about anything and everything to do with a comprehensive plan, because that's legislative, for better or for worse, legislative amendments are pretty labor intensive and costly for jurisdictions. So I think I just want to throw that red flag out there and that consideration for the good of the order.
Right, Dave, if you could hold 1 sec, thanks, Kelly. The one example that had me a little bit misled on how common this is was I happened to ask Patrick Windart, who's our South Willamette Valley Regional Representative early on, probably a year ago in our first phase of rulemaking. I said, hey, what does it look like for a change to a comprehensive plan? And in Lane County, as I recall, anyone could bring it. And it's a $25,000 fee. So it's not cheap. And probably that's meant to cover the processing time. It's a relatively high charge there, but it is, at least I know one county allows it, Kelly, but we haven't done a complete inventory. But not to underscore, sort of make light of your concern there. It's that's real. And
if I could just break in, Kirsten, briefly.
Yeah.
I think the idea was that if counties were required to do this, they would only allow it for this type of application as a legislative amendment, not generally. Because there are a few local jurisdictions that do allow legislative amendments to be submitted by an individual, and a lot that don't. And so this is a change. We realized this was a big change for a lot of local governments if they had to allow this, but we were thinking that they would allow it only for this type of application, not generally.
But thanks for that clarification. Dave, thanks for your patience. So I'll go to Nick.
Well, just to echo Kelly's concern, the problem is that you run into expectations. Somebody submits an application asking the county to make a legislative determination, and they're going to expect that the county is going to reach some kind of decision. And the whole point of legislative determinations made by the local government is that they're making policy determinations. They're acting like the legislature on state issues, and they don't have to make a determination. They can just decide we don't want to do it. And so by allowing individual applicants to seek a legislative amendment, I think you run the risk of creating frustrated expectations.
Mm-hmm. That's the drawback for sure. Thank you, Dave. Nick.
Yeah, thanks. So if I'm understanding the way the rule's written now, someone comes in with an application. Someone in the city has to determine, their first step is to determine whether that application needs to be processed by a quasi-judicial procedure or a legislative procedure. And that's a tall task, right? But that's true, correct? And so
yes,
I guess what I'm getting to is if we don't change this to along the lines of I think local jurisdictions are going to need more time to build a program that would be allowed to process these things, because we would have to adopt rules and zoning code procedures that would allow planners to be able to make these kinds of decisions and process these, because I don't think we could do that within a year. And I'm really worried about being able to implement this on such a short timeline.
Thank you, Nick. We had contemplated extending the effective date to June 30th, 2026. So that would be if commission made a decision in October, November, December, that would just be 8 months. So, we take your point, Nick, and I just wanted to put out that timeline that we have been thinking about out in the airspace, so that if folks, you're saying, for example, Nick, you're saying that, you would think the city of Portland would need longer. Others may be in the same boat. But thank you for that.
Yeah, because we would need a legislative procedure in order to set up for allowing to adopt the rules to allow us to have a quasi-judicial legislative amendment for these resources. And
exactly.
Those take longer than 8 months. They take longer than a year.
Well, yeah. Thank you. Thank you. Any kind of unspoken, unsaid comments? Nick, you had a comment in the chat, which is there any actual change to foresee being contemplated by staff? We haven't, this kind of is the question here is, did we get it right? You know, is the language here that the commission adopted right? And it leaves it open. I think, you know, what we've heard today is there might be benefit, what I've heard is there might be benefit to looking at the inventory and the significant steps differently. That's hanging in my head. And then I think, you know, Breeze had raised the other question is, who are the affected parties if that's property owners or persons? Amanda.
From my understanding, I think the subjectivity involved in the standard process for identifying significance is pretty similar to the subjectivity of determining what the protection measures should be. And I don't know, Dave, if you agree with that. So when you say trying to do those two things separately, I'm not sure how we need to address them separately. Both decisions would have to be made concurrently. Well, I mean, you only get, if you decide the site's not going to be added to the inventory, you're done. But if you decide the site is going to be added to the inventory, you have to move on to the step of identifying protection measures, and those two pieces are adopted concurrently.
Always.
Oh, yes. That's what we understand our rule to say. I mean, it doesn't mean anything to have something on your inventory if you haven't gone through the protection measures. That's why it's placed on the inventory, to get to the point of protecting Goal 5 resources.
Right. I just in this, if I may, in the really void of information we have on, you know, pre-contact presence on the landscape all across Oregon, I would think there'd be some benefit to an inventory resource, whether or not it's protected. But what you're proposing here is that there's no room for an inventory alone without protection.
Yes, and did someone want to say?
Oh, sorry. I was just going to say that's what 4E says, right? If you just scroll down to E.
I lose it. Yeah.
I'll say what you said first, or in part of what your statement, Kirsten, that it is valuable or can be valuable to have inventory, even if it's not connected to protection measures. I completely agree. I mean, that's partly what the National Register of Historic Places does. That's what Parks and Recreation does with their inventories. But since we're a land use agency, the function we're providing is directing what considerations need to be made around development. And so the function of a Goal 5 inventory is to inform development or lack thereof.
Interesting. I would just only push back to say that a comprehensive plan, I would say we're a comprehensive planning agency, and one of the main tools is zoning and land use, but we won't take everybody on that journey for our next long road trip. Breeze, please.
Yeah, I was just, Amanda pretty much said it. The other thing is, once those loci, whether it's a landscape element or an archaeological site, are identified, if it's an archaeological site, there's pre-existing state statute that addresses that. A landscape element is really where this steps in.
Mm-hmm. Okay.
I guess, yeah, my purpose in saying that is most of it's already addressed.
In terms of archaeology.
Yes.
Yeah. Right. Well, so. Okay. We are running into kind of the last 15 minutes of the meeting. You know, we're looking here for, did we get it right in 4C to leave it open? Nick has pointed out then it becomes the first job of at the local level to decide if it's quasi judicial or a legislative amendment. And then proceed from there. So maybe we got it right. It's good to discuss. Dave, you have a good comment in the chat. I'm gonna go ahead and paste it for everybody, just so folks can see it on Zoom or on YouTube if they watch it later, but do you want to put voice to that, Dave?
Yeah, all I was saying, Kirsten, is that I wouldn't bifurcate the goal 5 process, the significance determination from the level of protection determination. That's going to make a cumbersome process even more cumbersome. And so I don't know if anyone, it just sounded like that was a possible discussion topic, and I hope the group doesn't go that direction.
I feel like my trial balloon is quickly popped, you guys. So thank you for that. Amanda has long advised me, as we've been talking one-on-one, she said, why would you inventory something and not protect it? Why have these rules? So I get that. Okay. So, and Nick, you're saying, the next important question is, who can apply, and that is the main focus of our next meeting. Would anyone else like to share a perspective? We're all many experts on quasi judicial versus legislative. So deep ravine we've been in. So thank you for being there with us. It's an important one. Let's see. So just as we were saying, the next meeting, just as Nick was queuing us, who can bring the applications? Very important question. The tribal government representatives at the tribal work group that preceded the rulemaking have long advised that it would be tribes and other culturally identified groups. The commission initially asked us to develop rules around tribes and other culturally identified groups, but folks have expressed concern about this at this table and also at commission. So I want to take a look at that again. You heard from the Nez Perce tribe, from Miranda earlier, representative expressing concern with that. We've had comments from other out-of-state tribes in our previous process that they're on the record concerned with that, with not being able to participate directly anyway if we were to narrow it. So we just will need to be mindful with the pros and cons of narrowing. And then our third, if we can get to it at the second meeting, great. But another issue that the commission charged us with looking at is and a refinement of how to address a local government's responsibility within the context of a metro urban growth boundary extension. And Amanda and her team looking at implementation have noted that we just need to amend our rules slightly to cover treatment of comments in a public review process that doesn't require a hearing. We also have our impact statement review at our third meeting, which will, I'm sure, closely mirror the impact statement we all looked at last time. Anything, any other closing comments or questions, folks want to bring anything else up? I want to just see if Diane is still with us. Diane had raised in actually the Goal 5 solar area rulemaking a comment about the definition of cultural areas. And I just wanted to note that here that Diane and others may want to, tribal representatives may want to take a look at that term of cultural areas and see if we got that right as well. It's not anything the commission charged us with, but I know it's a carryover from the conversation at the Eastern Oregon Solar on farmland rulemaking process. So anything else incredible minds here. If not, I will let you go and we'll just kind of wait until our next meeting. We're looking at a challenging time in the summer, heading into end of school and summer. I think we're looking at June 12th, 16th, and 24th. Yeah, thereabouts, a couple half days in there. We'll try and Jess will send out a doodle poll. Sorry, best and worst friend. Please take a moment and check your calendars. I know that's very, a little bit tedious. We haven't figured out a better way. But looking to meet then, and then again in July, we might want to just go ahead and poll for both June and July at the same time so we can set that. And just really appreciate the extra discussion today to see if there's any changes that we should be looking at making. Commissioner Thompson, anything you'd like to say in close?
It's a good meeting when everybody gets smarter. So the level of expertise, the depth of the knowledge, and the balance of abstract principles with practical applications and the costs and the benefits of all of that, it's very good work. Thank you for the privilege of being here with you today. Come back soon.
Thanks, Commissioner. Thank you, everybody. We'll see you again soon then. You're 10 minutes back. Take care. Thank you.